Oh, thank you very much, Diane. So the recording is starting now, and we're about to start the presentation. I've forgotten to wait for that signal. So Diane, I have encouraged folks to ask questions, interrupt me. I'll be looking for that. But if for some reason I missed something, Diane, if you wouldn't mind notifying me, please, you're welcome to do that.
Okay, thank you.
Thank you. All right, well, let's begin. So we're going to start by talking about the types of commission cases, and I'll begin by doing a real high overview of the agency's general powers. So the agency has a wide range of powers over regulated entities. The commission sets rates and it determines the terms and conditions of service from regulated utilities. And then the commission is authorized to really investigate any aspect of that service, manage complaints, and take other actions to protect customers. So for those of you that aren't familiar, utilities, the regulatory compact allows utilities to have a certain degree of monopoly power in order to provide efficient service to customers. And the legislature has granted the Public Utilities Commission the power to stand in and protect customers from the improper exercise of that monopoly power. So in a typical market, you have a variety of actors competing with each other, and in theory anyway, that helps protect customers because customers have lots of choices in terms of the provision of service. Well, for utilities, we don't really have that. It doesn't make sense to have multiple different electric companies vying to serve your home, at least for the transmission and distribution infrastructure. That would result in an inefficient use of resources as duplicate or redundant systems would be constructed. So in return for a monopoly grant for a service territory, there's one utility, one provider of gas or electric or sometimes water service. In return for that, the legislature has created the PUC and instituted us with the power and authority to protect consumers, ensure that rates charged by these monopoly companies are fair and reasonable. And we work with the utilities to ensure this occurs. And in doing that, we have to make a tremendous amount of individual decisions, and we use a number of different case processes to do so. So the legislature gave us these unique powers, and they're pretty wide ranging. And we act in three different capacities. We have legislative powers, the power to adopt laws, and that's sort of what we do in a rulemaking, where we create rules of general applicability. We have executive power, and this is the power to enforce the law. In certain circumstances, rare circumstances, issue penalties. But also, it's the power to do things like provide licenses for specific activities, such as where we have competitive electric suppliers. We provide some licenses for that. And then we have an important judicial power. So it's the power to resolve contested cases between two parties, just like you'd see in a court, and issue a final ruling or determination resolving all the issues from that contested case. So those powers are not unlimited. That we are subject to a number of restrictions, which is part of the reason why the commission utilizes the public meeting process, which is the subject of our discussion today. So in terms of how we make decisions, we use four different primary processes. The one we'll talk about today is the first one, open meetings. So for those of you not familiar, the PUC roughly every 2 weeks, and then also sometimes in between, meets in open session. We used to do this before the pandemic in our hearing room in Salem. Now we do this virtually via Zoom. Any member of the public may attend. And at these meetings, the commission goes through a series of agenda items and either hears information, deliberates, or makes decisions on issues. They're listed by case number usually, or issue. And the commission generally, and we'll talk about this a lot more later, hears public comment, comment from affected stakeholders, and then discusses amongst itself and makes a decision. So those are open meeting decisions or public meetings. The second type of decision-making process we utilize are rulemakings. So rulemakings are codified rules which are kept and managed by the Secretary of State for the entire state, which generally implement some sort of legislation. So the legislature will pass a law. It's reflected in statute. It authorizes, or in many cases requires, the commission to issue rules explaining how that law will work, explaining how utilities may comply with it, how the public may interact with utilities on those issues. And then, so what we do then is we institute a rulemaking. This is a legislative process, and we conduct the process like the legislature. It's very open to public comment. Ultimately, when the commission makes a decision in a rulemaking, they must do so in an open meeting or a public meeting. So it's analogous to that open meeting category. Next is contested cases. So these are judicial-like proceedings. We'll talk a little bit more about that in a minute. And then finally, hybrid proceedings, which are technically open meeting items, public meeting items, but where we have some pretty complicated or challenging issues or a lot of stakeholders to manage, so that we manage them like contested cases. So a little more detail on these four areas. For the open meetings process, the commission generally likes to use these for issues that are time sensitive, a little less contentious, or a little less complex. That isn't always the case. We certainly do have quite a few public meeting items, given the nature of the subjects that the commission focuses on, that can be very complex and very contentious. But for the most part, it's utilized for something that is a little where fact finding in particular is less necessary. Where the commission has a lot of facts and to adjudicate, it utilizes the contested case process. It also uses the contested case process where individual rights or privileges or responsibilities are at stake. So, for example, if a party we regulate accuses another party we regulate of violating a rule or a law, we would almost certainly utilize the contested case process for that controversy. We would handle it like a trial because consistent with due process protections, which I'll talk a little bit more about later. The person who is aggrieved, who has both the person who is aggrieved and the person who has the rights or privileges at stake has a right to full due process and the opportunity to present evidence, the opportunity to build a record, and the opportunity to have that adjudicated and that evidence tested. So a hearing or trial-like procedure. We also use this for very significant cases with a lot at stake. For example, rate cases, which definitely also involve rights and privileges, but also just involve a tremendous amount of dollars at stake for companies and customers alike. Rulemakings, as I said earlier, we use that for any formal guidelines associated with a rule of general applicability. So if it's going to apply evenly to a broad group, say the legislature has said we must impose a new requirement on a utility, we would open up a rulemaking to figure out how to do that because it's a rule that would apply to all utilities. And then finally, the hybrid processes. So some examples here. I think the most prominent one is our IRP process. And for those not familiar, integrated resource plans are major plans that our electric and gas utilities develop that essentially lay out how they're going to provide service to customers for a period of years. They involve a tremendous amount of analysis, a lot of public interest. And so we typically use a hybrid approach where an ALJ or an administrative law judge will manage the case for the commission as though it were a contested case or a judicial-like case, at least for a large portion of the case. But ultimately, there is no formal rights or responsibilities or at stake, given that in an IRP process, a utility is presenting a plan to the commission, and the commission is deciding whether or not that plan is reasonable, to put it succinctly. So there's no real tangible, there are practical impacts, but there is no real tangible impact to a utility based on the commission's decision. It's more, it's a bit more than advisory, but it doesn't create any rights or privileges that we have to adjudicate. But it's still a very important process. The commission takes it very seriously. Certainly the utilities and our stakeholders take it very seriously. So we use this hybrid process.
Nolan, we have a question.
Yes, absolutely.
The question is, how is the decision made as to how the case will be processed? Who makes that decision?
That's a great question. Ultimately, it's the commission's decision. The commission can delegate responsibility, however. So for some issues, for example, staff may propose to handle an issue in an open meeting. The commission will put that agenda on, or that item on the agenda, and staff will attempt to move it forward. But if anyone in the public or any stakeholder decides, you know what, this really isn't appropriate for a public meeting, we think this should happen in a contested case, they have a couple options. They can talk to staff about that directly, or ultimately they can go in front of the commission when that item goes before the commission and argue that it should be transferred to a contested case. So the commissioners are the only ones that technically make that decision, but they delegate it. So when we have certain cases come in, there's a group of folks in the agency that can play a role in deciding how they will be handled. But if any member of the public disagrees with that, that decision is always elevated to the commission in one way, shape, or form. So that's a great question. Okay. So now let's get into the public meeting process in a little more detail. So our public meeting requirements, what makes our public meetings what they are in terms of what we do and why we do it, those are encapsulated in two key statutes. Oregon's open meeting law, which is in chapter 192, and then our Administrative Procedures Act, which is in chapter 183. So of those two, the open meetings law is most impactful for us. Essentially, this requires that decisions of governing bodies must be made through an open process. That means a couple things. The process must be open to the public. So the decision must be made in public. So practically what that means is if an agenda item is set up for decision in a public meeting, the commissioners can't discuss it privately. They can't discuss it as a group together prior to the meeting. They can't discuss it one-on-one. They must review it in a public meeting. And they must decide together in a public meeting. So they can't decide prior together Of course, individually, they can always make up their mind on what they want to do, but as a group, they cannot discuss and decide unless they do so in a public. The public must have notice of the meeting. So we can't just schedule a meeting and not inform the public. The public has to be informed. There are some procedures by which we can hold emergency meetings. We can hold them very quickly, but even in that case, we have to do our best to notify the public that the meeting is going to occur, and we have to tell the public what's going to happen at that meeting. We try to get notice out well in advance of all meetings. There are a few occasions where an emergency meeting is necessary. And then finally, meetings must be very accessible to those wishing to attend. So, and that accessibility means all things. It means we must work to accommodate anyone who wants to participate, regardless of their needs. And we must make that information available early so that they have the full opportunity to participate. And so recently that's been a little easier given what we're doing with Zoom. In the past, of course, we met in Salem. But regardless, we've been live streaming our public meetings for a long time now, and folks have had the ability to call in as well for a long time. So the commission takes that requirement very seriously. The Administrative Procedures Act puts a couple of restrictions on the commission with regard to rulemaking. These aren't terribly different than those in the Oregon meeting or the public meeting law. We have to provide adequate notice to the public. We have to provide plenty of opportunity for comment, and then we have to make our decision in an open meeting using the public meeting process. The PUC, so the Administrative Procedures Act is an important act for most agencies in state government. It's important to remember, though, if you're ever taking a look at it and thinking about its role to the Public Utilities Commission, the Public Utilities Commission is one of a number of agencies that are exempted from a significant portion of its provisions. We have similar provisions in the statutes governing our specific operations. But it's just important to note that that we're not subject to some of the Administrative Procedure Act. So, getting more into the mechanics. So prior to the meeting, an agenda gets developed, and you know, to sort of explain, we had a great question earlier about how a case gets designated, whether it be a contested case or non-contested case. Similarly, you know, the commission makes some internal decisions about what to put on the agenda. So ultimately, the commissioners approve the agenda, but it's proposed by staff. It can be proposed by other members of the commission. And it can also be, the agenda can be impacted by public need and by public requests. So typically that runs through staff where members of the public or the regulated community or stakeholder community will indicate to staff that a very important issue needs to be addressed, and staff is typically responsive to making sure that that issue gets on the agenda. Pretty typically, our agenda items are driven by statutory rule or by statutory or rule-based deadlines. So if the commission needs to make a decision by a date certain, you're likely to see the commission take action on that a bit ahead of time. So a lot of our agenda items are driven by those factors. So notice, there will be ample notice before the public meeting. We must provide that notice in writing. We include the time, the place, and the content of what we're going to discuss. And you'll see these in the public meeting agenda notices that we issue and that are found on our website. And then, as I discussed earlier, we also must provide information on how to access and participate in the meeting. Okay. So again, prior to the meeting, there'll be a lot of content typically posted online, and we post it as we get it. So you'll see staff reports for each agenda item. So you may have let's say we got a docket, it's called, UM 3000. Well, UM 3000 will be listed on the agenda. There'll be a short summary or a heading of what it is, less of a summary, more of just a heading. Hey, this is an agenda item to review utility procedures on renewable energy, or as an example. And then you'll have a staff contact. You'll have contact information of folks that are sponsoring the agenda item that you can reach out to if you have questions about it or if you want to comment on it. You can also reach out to the commission directly to prepare for comment. We'll talk about that in a minute. The online content also includes comments. So if folks have been filing comments on a specific agenda item, you'll find that online. We try to post those in real time, so there's a little bit of a lag. We get them, they get sent to the commissioners and they get posted sort of simultaneously, but they are typically available online before the public meeting, depending on when we get them. So importantly, to stay aware of our public meeting agenda items, you'll want to get to know our website, which we just encourage in general, but they are always posted there. And then additionally, if you're interested in a particular item, you'll want to get on the service list for that item, be it a rulemaking or another type of docket. If you're on the service list, as soon as the notice is ready, and you'll get notification of that, so that the agenda item that you are interested in will be on an upcoming agenda. So the structure of the public meeting. Our public meetings have always been open to general public comment, but more recently we've been carving out an explicit time for that. So the first roughly 15 minutes of a public meeting are allocated for general open comment. So what this means is that any member of the public may speak to the commission on any, we hope, commission-related issue, except those on the agenda. And that member of the public can still speak to that item, but just has to do that during the allotted time in the agenda. Importantly, due to the public meeting laws, the commissioners cannot provide substantive feedback or take action on this general comment. So if you come to the commission, say you have an issue you want to raise and you think it's an important one, you think the commission should hear about it, they will definitely hear you. You can come forward and present that information. They may even ask a question or two, but they cannot provide any substantive feedback or take any action at that public meeting, because that would violate the public meeting law. We wouldn't have noticed that. Other members of the public wouldn't be aware of it. So it wouldn't be fair to them for the commission to, say, order a utility to fix a right-of-way clearance issue in a public meeting on an issue that no other individual had been given notice of. So while you may bring your issue forward in a public meeting in this open comment period, the commission won't take any action on it at that public meeting. The commission can, however, listen to you and decide, you know what, that's an interesting point you've made up, you brought forward. We need to address that in a future public meeting, or we need to have staff look into that. So action can come out of it, but it will not happen during that public meeting. So if you do bring an issue forward, don't be discouraged by the fact that the commission isn't saying anything about it. Really, according to consistent with our public meeting law, the commission doesn't want to do that. It wants to make sure that the public has full notice of an issue before they start reviewing it or having deliberations. So that's the first part of the public meeting agenda. The second part is devoted to the consent agenda. So the consent agenda is exactly what it sounds. These are items that are not very contentious. These are items that the commission on its own, the commission is essentially going to approve together. The commission has decided, or we anticipate, is a better word, that we anticipate that the commission will have no discussion on these items, and we don't anticipate any public comment. So this is more of a convenience issue, given the wide number of decisions the commission makes. When we do have pro forma decisions that the commission must make, but where, for example, if we're approving a tariff filing or a tariff proposal, and staff is supportive of it, obviously the utility proposing the tariff or the change in rates is supportive of it. Members of the public or trade groups have expressed support. If it's a not very significant change, it might end up on the consent agenda. Given the breadth of business that the commission has, it's helpful not to have to take each item individually and discuss it. So that's how items end up on the consent agenda. If, however, any member of the public wants to comment on that agenda item, it gets moved. It gets put in the regular section with the rulemaking agenda. And that can happen right at the beginning of the meeting, because we may not find out if there's a member of the public wanting to comment on an issue until the meeting starts. Third, and sometimes fourth, it really depends on how things are flowing in the individual meeting. We have the rulemaking agenda. So the rulemaking agenda, we handle rulemakings through the public meeting process. Often it can be like a typical agenda item. There may be a report from staff, such as a recommendation to open a rulemaking. If that's the case, there'll be full opportunity to comment, just like a regular public meeting item. You can come up, you can talk about it. You can argue that the commission should do something different than staff has proposed, and just make your case in general. If, however, the commission is just meeting to adopt a rule, so this would be after a full public comment period, after public comments have been summarized and presented to the commissioners, after there's been a hearing to hear additional public comment. If after all that, the commission's ready to decide, they do so without public comment. And the idea there is that the commission have, that there's a period by which the commission can deliberate and decide after all public comment has been received and synthesized. So that's the rulemaking agenda. And then finally, the real meat of it is the regular agenda. So these are items either requiring some commission discussion. Usually there's a staff presentation that kicks things off. And these are typically items with some public interest attached to them, and where folks have indicated that they'd like to comment. So the typical process here, it's pretty basic. Staff will go through its report or its recommendation. After that, if you've identified yourself as someone who wants to make a comment, you'll be invited to do so. The commission typically lays out an order by which they'd like to hear comment. There may be back and forth. There may be questions from the commissioners. After all that, the commission closes off public comment and then talks amongst itself to make that publicly made decision. So let's talk a little bit about how you would participate in a public meeting. It depends a little bit on the type of case and the stage we're in. I'll mention two types of public meeting items first, just so you know what this means. So sometimes we have items that, as I just discussed for rulemakings, that are deliberation only or informational only. So these are public meeting items where you won't be able to make comments. For the first type, for the deliberation public meetings, essentially the commission has taken in all the information. They've provided ample opportunity to comment, provide written materials, and now it's time for them to get down to business and make a decision. And so these are very interesting meetings to watch, I can tell you that. But essentially, they're discussions between the commissioners, and they're going to weigh a bunch of issues and make a decision. They're doing this in public because of the public meetings law. As you can probably imagine, it's a little bit easier for the commissioners to make a decision, in a conference room, talking together about all the issues they care about, than it is to do that out in public. But it's very important that we follow the public meetings law. And so we do have specific deliberation only meetings where the commission, we're essentially staging the ultimate decision and have set aside some time for the commissioners to speak together in public, review the issues they care about, and make a final decision. There's also informational only meetings. These are more updates, presentations from specific groups. So, for example, the Public Utilities Commission works with the Energy Trust of Oregon, and the Energy Trust of Oregon often provides a lot of reporting to the commission, the status of programming, the status of budgets, things like that. And so the Energy Trust does have some informational only meetings where essentially it's providing just an update to its regulator. At those meetings, the commission isn't deciding anything, it's just hearing information. But if the commissioners want to hear that information all at the same time and together, they've got to do it in a public meeting. And so that's why we schedule it. For all other agenda items, as I said, the commission will hear comments, oral comments, and will receive written comments. So for preparing and submitting documents, what you'll want to do is submit the comments to the filing center. There are instructions on our website. It's pretty self-explanatory. The filing center is really the front door of the agency when it comes to sharing and distributing documents. So they get the comments, they post them in the docket, they ensure the commissioners get them. And so it's very important to be responsive to the folks in the filing center to make sure that you answer their questions and you provided everything they need to make sure that your comments get to the right place.
We have another question.
Great.
The question is, does the commission ever discuss and make decisions in private? If so, what type of decisions are they making?
That's a great question. I think you've sort of identified a gap in this presentation. So they do, they absolutely do. And they do that in contested cases exclusively. So the only decisions that the commission makes other than those in the public meeting are those in contested cases. So these are the judicial-like proceedings where you have a major, say, major rate case proceeding, or you have a complaint from a customer to a utility. Whenever we handle those as contested cases, and this is very clear to the participants, we make that very clear at the outset. Everyone is given notice of this. For those cases, evidence is tested, compiled, presented to the commissioners, and then they review and make a decision in a decision meeting. These are official meetings where we have representatives across the agency present to answer background information questions from the commissioners. But they have to be carefully scheduled. And only certain people can participate in them. For example, because in some of these cases, staff may be a party, only specific advisory staff may participate in these decision meetings. So the commissioners will get together in these decision meetings, they'll review a draft order, or they'll discuss issues and direct how they want an order drafted, and they'll make a final decision. I'll also say that other decisions, the agency is also an organization, and it has organizational decisions to make. According to our delegation order, most of those decisions have been delegated to the chair, and she has the authority to delegate them to specific personnel across the agency. So there are many other individual decisions that get made, quote unquote, by the commission throughout every day, throughout the agency every day. But those are often internal decisions on how the commission is run as an entity, and those are delegated from the chair. But that's a great question.
We have another question.
Sure.
Oh, just a moment, I lost it. I'm sorry, all of a sudden my screen is frozen. It says, if the commissioners are requesting as early as possible written comments, is there a minimum amount of time set that any public comment opportunity is held to, example, minimum of 5 business days from release of the staff documents to when the public meeting is held to consider written comments?
Yeah, that's a great question. So there is no specific time. Technically, I think commissioners would, although this is recorded, and I think the commissioners would be upset if I told you this. Our commissioners are extremely diligent. I've rarely run into a situation where they haven't been able to read a comment, even a very late filed comment. However, they very much appreciate it if you get them in as early as possible. I do think there's a pretty significant cutoff when it comes to 24 hours before a meeting. If the comment hasn't come in 24 hours before the meeting, you're more likely to end up in a situation where the commissioners just haven't had time to review it. And the reason could be because they received it and just didn't have time, or it could also be because if it's filed at a certain point the day before the meeting, it may not be processed in time for the commissioners to see it. So there is no formal time, but the commissioners very much appreciate it if comments can be received as early as possible. But I will say that, like I said, they're very diligent, and I think it's a pretty rare circumstance where they haven't been able to read a comment. And of course, if you have any question about whether or not your comment can be read in time, you can always attend the public meeting and summarize your comment and explain to the commissioners your points of view. Okay, any follow-up on that, Diane?
I don't see any, thank you.
Okay, thank you. All right, so the commission, as you haven't if you haven't already gathered, the commission doesn't like to be surprised. So it's highly appreciated, but again, not necessary to notify the commission prior to a meeting if you're going to participate. So the instructions for doing so are on the notice. You can let commission staff know that you're intending to participate, that you'd like to make public comment. It makes it easier for us to prepare. We can make sure to call on you during that public meeting agenda item. And again, I counsel you to take a look at those instructions and explain to the team that you'd like to make a public comment. But again, it's not necessary. If for some reason you only just heard about a public meeting item, needed to get on the morning of and essentially pipe up and make your comment, we can accommodate that. Some just general recommendations for offering oral comment. You want to stay focused on the agenda items. The commission has a duty to try to stick to the agenda items. This is given the public meetings law. So even if they really want to talk about an issue that isn't on the agenda, if your comments are very much focused on issues outside the agenda, even if you think it's important context, it can be a challenge for the commissioners. They have a little less flexibility to talk about that. So to the extent possible, you want to stay focused on those agenda items. You want to be sensitive to time restrictions and needs. Our public meetings are running quite long recently. And I think that's, the technology that we have now is Zoom. It just makes it a little bit easier to have these. More folks are participating, and that is fantastic. But quite often they'll run well into the afternoon, and that's fine. But sometimes the commission will say, look, we only have a certain amount of time to handle this agenda item. If you hear that, just counsel you to be sensitive to that and responsive. And then, of course, be responsive to commissioner questions. Having participated in a lot of these meetings, I've found that advocates who are truly effective listen to the commissioners and attempt to answer their questions. The commissioners, they don't engage in gotcha questions, or at least they haven't in my experience. They're genuinely trying to figure out where the gaps in an argument or an issue are. So I think you're well served to explore that with them. That will help them understand your point of view and understand how your point of view fits into a broader issue that they may find challenging. So that's just, advice that you do not have to take, but just some friendly advice. So after the public meeting, so we record and archive all of our public meetings. So these are available to you. You will find them on the website. Typically there's video and audio. Written minutes are also kept and posted. The written minutes are pretty scarce. I mean, essentially they mention the agenda item, who participated, that a decision was made. So if you're looking for true detail, the recordings are probably best to take a look at. So following the public meeting, an order gets developed for each agenda item upon which the commission made a decision. These written orders can be pretty short. Some of them will be signed by me and not the commissioners. The commissioners have delegated that responsibility for public meeting decisions where they have just adopted staff's recommendation. However, they can sometimes be very long. For example, an IRP decision, as I discussed earlier, that's technically a public meeting decision. And sometimes those orders can run 10, 20 or more pages ultimately. And that reflects the breadth of issues that the commission must resolve in those cases and consider in those cases. So what happens is that there's almost always an assigned ALJ, administrative law judge associated with a public meeting item. They follow along. Sometimes they participate in the decision-making process by helping the commissioners tee up issues in a public meeting decision. And then they work to develop an order afterwards. And that order, because the decision itself was made in the public meeting, that order must reflect what was decided at the public meeting. So whenever you see an order coming out of a public meeting, it is not a reflection of some subsequent conversation that the commissioners may have had together. It does not reflect a follow-on decision meeting. It must reflect what the commissioners talked about and what they decided in the public meeting. That is the decision. And also that is the date the decision is made. So sometimes you'll have an order come out a week after or 2 weeks after. Occasionally, for instance, we've had a few IRP orders like this. It may be several weeks after, but the decision dates from the day the commissioners made it in that public meeting. Okay, so I'm going to move on to the next slide. All right, we're going to talk. So that's sort of how the public meeting process works. And then I was going to talk a bit about the technology. But before I do that, I want to open it up to discussion and questions about the public meeting process itself and what we just went over. So are there any sort of global questions that we missed that folks didn't feel got answered? And it's okay if not, I can go into the sort of how to participate in our public meetings using Zoom.
Nolan,
Yes.
it looks like Heather Moline has her hand up.
Oh, great. Heather, yeah, we'd love to hear from you.
Hi there. I think my question is there a sense of when at commission processes utilities are necessarily the first people, the first stakeholders to speak, because they need to provide information before others can comment on it, and when it's sort of first come, first serve, whoever sort of raises their hand and wants to get on the list. Because I've been doing this for about 1.5 years now. And sometimes I feel the agenda fills really fast with people who know what they're talking about and who have a lot of folks in the room. And other times there's a very intentional sort of let us know, and according to when we receive your name as wanting to speak, we will put you on a list.
Yeah, that's a great question. And there is no sort of written tablet that we look at behind the scenes to figure that out. It is a case by case, agenda item by agenda item determination. That's one of the many things that's sort of delegated to the chair to manage the process of the public meetings. I think that your question, I sensed a bit of a comment. I think it's a good one, that the commission can be more sensitive about how it structures each public meeting agenda item and who gets to speak and the order in which they speak. I think it's something that we can probably be a bit more deliberate about and think a little more deeply about how we structure each agenda item. I will tell you that generally there is a sort of unspoken procedure where if we have a significant, well, almost always staff goes first, as you know, to explain their recommendation. But if the meat of what the commissioners are going to decide, it has a lot of technical questions that can only be answered, or in part can only be answered by the utility. They're going to want to hear from the utility pretty early on in the decision-making process, not only for their own benefit, but also for the benefit of the commenters that might come after. But I think your question is well taken in the sense that that's good feedback for us and for the chair to think about how we structure who gets to speak and how they get to speak for each item. So I don't know if you have any follow-up after that, but I think that's a very good question.
No, that's really helpful. And I really have, the commission regulates private utilities. So it's, so you have to hear from those folks because that's what you do principally. But yeah, there might be room for, certain processes to very specifically want to hear from others and prioritize input from others. There may be some sorts of meetings where it makes sense for everyone to be in the room and to hear the information that utilities have to provide. And then there may be other situations I've found where it's not the best use of time for everyone to be invited to one thing.
Sure.
To hear a bunch of technical information and then reserve sort of 5 minutes for comment at the end. So yeah, you've answered the question. I appreciate you interpreting it as a general comment as well.
Well, I think it's a good one and it's helpful.
We have another question.
Sure.
It is, what is meant by ex parte communication?
Oh yeah, great question. So ex parte communications are an issue we deal with in our contested cases, our judicial-like proceedings. And in a contested case, a judicial case, there's a group. It's the 3 commissioners along with the presiding ALJ. They are judges in the case. So if I'm assigned to a case, a contested case as an ALJ, I have to act like a judge on the bench. And what that means in practice is there's a high degree of diligence around fairness. And so for a contested case, when a party to the case, the plaintiff, the defendant in the case of a complaint, or just a party in a general case, when they make an argument to the judge that ultimately is going to decide the case, they need to do so in full view of the other parties. If they present evidence to the judge, they need to do so in full view of the other parties. And the idea being that due process requires all parties the opportunity to react to that argument, or all parties the opportunity to react to that evidence. So, for example, in a case, you can't just provide evidence privately to a judge. You have to present that, and the other parties, if they disagree with it, get to put on conflicting evidence. And so, what ex parte is ex parte is not a prohibition, but it's an opening of the process. So in a situation where a party has had a conversation with either the ALJ assigned or the commissioners. So if you're a party in a case and you happen to see, one of the commissioners out at the farmer's market, and you guys get to talking about your complaint or your case and start talking about the content of it, that's an ex parte communication. That's a communication between a party and the judge. And it happened outside of the case process. It happened outside of the view of the other parties. So we have an obligation as judges in that case to disclose that. And so what typically happens is if anyone on either side and feels that that an ex parte communication has happened, they'll disclose that to me typically, and I'll put something in the docket explaining what happened, who talked to whom, and then allowing everyone else the opportunity to respond to that. That is an issue for contested cases. It is not an issue for other than contested cases or public meeting agenda items or rulemakings. So for any of those other items, if you're an advocate and you want to talk to a commissioner about that issue, say rulemaking, you can do that. Now the commissioner may decide, I'm not going to talk to anybody about this while this rulemaking's ongoing. I might talk to them before. That's their prerogative, but there's no prohibition on it, and there's no requirement that get disclosed. So that was a good question. Any others? Okay. Well, I'm going to start sharing my screen again. One moment. Here we go. Share screen. All right. Okay, so we'll talk a little bit about Zoom. So we're using Zoom for all our, right now, all our contested case proceedings, our hearings, as well as our public meetings. We're using it right now, I believe. I should know that, but I believe we're using Zoom. So it's a pretty self-explanatory system. All of you here on this meeting have utilized it before, or you're utilizing it right now. It's cloud-based. It doesn't require you to install any software. It's widely utilized, and I think folks are getting more and more experience with it across their daily life. And we're going to use it really until it's safe to meet in person again, which some of us can't anticipate enough, but obviously we're not there yet. Okay. Oh, sorry. Accidentally. Let me go back here. Okay, there we go. So just some suggestions. I'll keep it brief here because I think a lot of you are already familiar with this. When you're getting ready for a public meeting, just check your technology, make sure you're connected to power, that your internet connection is good as possible. if you're going to have your video on, and you don't have to make a public comment or to speak in a public meeting, you'll want to test your video. And then you'll really want to make sure all your disruptions are off. Like I said, you want to mute your phone as well. You'll want to turn off other notifications. You probably heard one of my email notifications. I didn't take my own advice for this meeting. You'll want to avoid using a mobile device if you can. So smartphones and tablets can allow you to use, you can use Zoom on them, but we found that the quality isn't as good and the feature is a little limiting. So for highest quality, you're best off using a laptop. You want to avoid noisier echoing locations, and then you'll want to avoid distracting real or virtual backgrounds. You'll notice that I'm in an office here. I actually came into our Portland office to do this meeting because my home real background is quite distracting. So I did that. You'll want to work on your camera positioning and try to frame yourself. And then, of course, avoid running any unnecessary applications to conserve power and the ability of your computer to network. So during the public meeting itself, you really want to make sure you follow instructions around Zoom. So the chair may limit video in certain instances. She'll just provide general instructions based on the needs of the day. You'll definitely want to make sure your video is turned off until it's time for you to present or speak, if you're a presenter or a panelist. And then if you're just offering general comment, audio only is fine. The commissioners are comfortable with it. Of course, you're welcome to use your video, but if you just want to use audio, that is fine. And then if you really want full functionality, you want to join on time. I've noticed that sometimes, I think automatically, if you join late, for some reason, videos can get turned off. So that's something to pay attention to that we really want to try to join in a timely way. So I'm going to finish up. I just want to thank you for participating today. As I said earlier, all this is going to be available online. My contact information is below. And we really are committed to doing more of these and making them as accessible as possible to folks. We want to demystify our processes and also learn. We do learn from your questions. I think I already have some feedback to take back to the commissioners today. Like I said, please feel free to reach out to me at any time. If you have any questions or thoughts or suggestions, big or small, my virtual door is open, and I look forward to hearing from you. Oh, and let's see, Diane, do we have any final questions?
I don't see any more questions.
Okay. Well, thank you, Diane. Thank you, everyone, and have a great afternoon and happy holidays. Goodbye.
Thanks, you too.